Big news about Hus agreements.
Hi, I'm Blake Lively, and I'm going to be taking the BuzzFeed quiz, which iconic Blake Lively character?
Hey besties, welcome back. What we're about to talk about today isn't just celebrity drama. It isn't just another Hollywood headline meant to trend for 48 hours and disappear. This situation feels different. It feels heavier. Because when you strip away the glossy magazine covers, the red carpets, the charming late-night interviews, and the perfectly curated Instagram captions, what's left is something far more unsettling: power. And how far powerful people may be willing to go when they feel threatened. There's a message embedded in everything that has unfolded over the past year. It's not a message that was delivered in a press conference. It wasn't typed in a tweet. It wasn't whispered into a journalist's ear. It was embedded in legal paperwork. In a subpoena. In a lawsuit that appeared suddenly, moved quickly, and then disappeared almost as fast as it arrived, and the message, whether intentional or not, was unmistakable. If you cross us, we will go further than you ever imagined. The controversy centers around a subpoena that reportedly sought deeply personal communications from individuals connected to a public relations firm. Not a celebrity. Not a public official. Not someone who had chosen to step into the spotlight. A private individual working at a company. Yet through a legal action tied to a corporate entity connected to Blake Lively and Ryan Reynolds, a sweeping request was made for communications, emails, chats, messages, documents across multiple platforms. Now let's pause for a moment. Subpoenas are legal tools. They exist for a reason. They can be appropriate. They can be necessary. But what makes this situation controversial isn't simply that a subpoena was issued. It's the breadth. The scope. The depth of what was allegedly requested. Communications across Gmail, Outlook, Signal, WhatsApp, Telegram, Instagram, TikTok, Facebook. Chat logs. Voice messages. Notes. Photos. Location data. Metadata. The kind of digital footprint that, in today's world, essentially maps a person's entire private existence. And here's where people began asking questions. Why would a company originally described as handling payroll and administrative matters for household employees suddenly become the vehicle for this kind of legal action? Why wasn't the lawsuit filed under a personal name if the matter was personal? Why was it initiated through a corporate structure reportedly designed to manage staff benefits and NDAs? Those questions don't automatically equal wrongdoing. But they do raise eyebrows. According to testimony referenced in court discussions, this company, established after Blake and Ryan's marriage, handled payroll, benefits, and non-disclosure agreements for household staff. Assistants. Security. Administrative personnel. Standard celebrity infrastructure. The kind of entity many high-profile families established to streamline employment matters. But then, this entity initiated litigation in state court. A lawsuit that led to a subpoena directed at a PR firm, Jones Works. A subpoena that reportedly demanded extensive digital communications. And after the materials were produced, the lawsuit was voluntarily dismissed. That timeline is what fuels suspicion among critics. File lawsuit, serve subpoena, receive documents, dismiss lawsuit. To some observers, it looks strategic. To others, it looks procedural. The interpretation depends entirely on where you stand. But here's the larger issue: we are living in a media environment where trust is fragile. Where public figures are either idolized or demonized, rarely evaluated somewhere in between. Where mainstream outlets are accused of protecting power, and independent creators claim to be the last line of transparency, social media has reshaped the hierarchy. 20 years ago, a celebrity scandal was filtered through a handful of magazines and network newsrooms. Editors decided what the public saw. PR teams controlled the narrative. If something damaging surfaced, it could often be contained. Today, that control is fractured. Anyone with a microphone, a camera, and Wi-Fi can dissect court documents in real time. Legal filings trend on TikTok. Depositions are summarized on YouTube before journalists finish drafting articles. The power dynamic has shifted, and not everyone is comfortable with that shift. Blake Lively and Ryan Reynolds built their public brand on charm, relatability, and wit. They cultivated an image that felt almost untouchable. playful social media banter, carefully staged interviews, philanthropy, humor. For years, they were the couple everyone rooted for, which is why this controversy feels jarring, because when allegations emerge suggesting aggressive legal maneuvering, invasive discovery tactics, or strategic information management, it clashes violently with that polished image. And when powerful law firms enter the picture, firms known for corporate litigation rather than individual representation, it amplifies the perception that something bigger is happening behind the scenes. Critics argue that the subpoena was excessive, that it sought information unrelated to the stated dispute, that it swept up communications involving third parties who had no connection to any alleged wrongdoing, that it risked exposing private individuals' data unnecessarily. Supporters might counter that litigation often requires broad discovery, that attorneys routinely pursue extensive document production to identify relevant evidence, that what looks invasive to the public may be standard practice within complex legal battles. Both perspectives can exist at the same time, but here's what undeniably unsettles people: the idea that personal digital ecosystems, years of conversations, photos, notes, locations, could be accessed through litigation involving individuals who never signed up to be public figures. Because in 2026, your phone is not just a device. It is your diary, your therapy sessions, your family history, your arguments, your health updates, your fears, your late-night thoughts, your entire life compressed into a screen. So when legal action appears to target that level of access, even if procedurally permitted, it triggers something primal in the public psyche: fear. And fear spreads faster than facts. The controversy deepened when observers pointed out an apparent contradiction. On one hand, there were claims about certain communications being unavailable or destroyed. On the other hand, requests were allegedly made for those same types of communications from others. Critics asked, how can one party claim certain data no longer exists, while simultaneously demanding similar data from someone else? Again, allegation versus explanation. There may be legal nuances. There may be timing distinctions. But in the court of public opinion, nuance rarely survives. Then there's the media component, because whenever court-obtained information finds its way into major publications, people start asking about pipelines. Who provided what? Was everything contextualized? Was only the most damaging material highlighted? Were counterpoints equally represented? These questions aren't unique to this case. They surface in every high-profile legal battle. But in an era where accusations of narrative manipulation are constant, they hit harder. Some commentators have gone further, suggesting the lawsuit functioned as a mechanism to legitimize information already obtained through other means. That's a serious claim. An explosive one. And it remains firmly in the realm of allegation. But even allegations shape perception, and perception shapes reputation. That's the part that truly matters here. Reputation. In Hollywood, reputation is currency. It determines casting decisions, brand deals, investment opportunities, access, power. Once it fractures, rebuilding it is nearly impossible. So when critics frame this legal maneuvering as a warning shot, a message to anyone within orbit, it resonates. The implied warning being, compliance ensures protection, opposition invites scrutiny. Is that interpretation fair? That depends on evidence not fully visible to the public. But the narrative has taken hold in certain circles, and narratives, once formed, are hard to erase. The most haunting element of all this isn't the paperwork itself. It's the psychological ripple effect. The idea that colleagues, business partners, or former associates might hesitate to speak openly for fear of becoming entangled in litigation. The chilling effect that can occur when powerful individuals demonstrate their willingness to engage top-tier legal resources, because litigation is expensive, exhausting, time-consuming. Even if you ultimately prevail, the process can drain you. That imbalance of resources is what makes these stories compelling. Not celebrity gossip, power asymmetry. Critics argue that this wasn't merely about resolving a dispute. It was about control, about narrative dominance, about ensuring that certain stories gain traction while others are neutralized. Supporters would likely argue it was about protecting reputations from false allegations, about defending against smear campaigns, About using lawful tools to uncover the truth, both narratives cannot simultaneously be 100% accurate. But both continue to circulate. What's undeniable is that fear has entered the conversation. Fear among insiders. Fear among observers. Fear that if you end up on the wrong side of a powerful couple with extensive legal backing, your digital life could become discoverable terrain, whether justified or exaggerated. That fear is real, and once fear takes root, it spreads quietly. As for the lawsuit being dismissed after documents were produced, legally, voluntary dismissals happen for many reasons. Settlement discussions. Strategic recalibration. Jurisdictional considerations. But critics interpret the timing as suspicious. Get the documents. Close the case. They see that sequence and infer intent. Intent, however, is one of the hardest things to prove. What makes this entire situation combustible is the broader cultural backdrop. We are living in a time when institutions are questioned, when mainstream media credibility is debated daily, when independent creators claim to expose truths others won't touch. In that environment, even routine legal strategy can morph into something sinister under the right lighting, and Blake Lively and Ryan Reynolds, fairly or unfairly, now find themselves under that lighting. The message critics believe was sent is stark. We have reach. We have resources. We can navigate systems you can't. We can access information you assumed was private. Whether that message was intentional or simply perceived, it has changed the tone of the conversation around them. The bigger question is what happens next, because controversies like this don't vanish quietly. They evolve. They escalate. They either collapse under lack of evidence or expand under new disclosures, and as more filings surface, as more testimony becomes public, the narrative will either solidify or unravel. But for now, the disturbing undertone remains: not proven crimes. Not confirmed misconduct, but a perception of overwhelming power deployed in ways that feel invasive to many observers, and in a culture already skeptical of elites, that perception alone is explosive. The role of media amplification, the fallout among insiders, and why some believe this battle is far from over. To be continued. Because here's the truth about high-profile legal warfare: the courtroom is only one battlefield. The media is another. Public perception is another. And private industry relationships? Those may be the most fragile of all. When the subpoena controversy became public knowledge among industry insiders, the conversation reportedly shifted from "is this legal?" to "how far can this go?" And that's a very different question. Legal? Perhaps strategic? Possibly, but how far? In Hollywood, power doesn't just come from fame. It comes from access. From the ability to pick up the phone and call studio executives. From relationships with major law firms. From publicists who can shape headlines before they're printed. From journalists who rely on insider tips for exclusives. When that kind of network exists, it creates something invisible but powerful: insulation. And critics argue that insulation is exactly what allowed this situation to escalate without immediate public scrutiny. Because think about it. If a lesser-known figure had filed a sweeping subpoena seeking years of private digital communications from individuals connected to a PR firm, including chat logs, voice messages, and metadata, would the reaction have been different? Would headlines have been harsher? Would there have been louder calls for oversight? It's impossible to know for certain. But perception matters more than certainty in the court of public opinion. One of the most debated aspects of this controversy isn't even the subpoena itself. It's the alleged transfer of information. The chain of custody. The question of how documents obtained in one legal action may have intersected with another dispute involving different parties. Now, to be clear, complex litigation often overlaps. Documents produced in one case can become relevant in another. Lawyers coordinate. Strategies evolve. That's not inherently improper, but critics argue that the sequence here felt engineered. They point to the timing. They point to the dismissal of the original lawsuit after materials were obtained. They point to media coverage that appeared shortly thereafter, citing information described as court-sourced, and that's where the skepticism intensifies, because once information enters the media ecosystem, it rarely arrives neutrally. It arrives curated, selected, contextualized. Sometimes framed in ways that amplify certain narratives while minimizing others. This isn't unique to this case. It's the nature of media strategy. But when you combine aggressive legal discovery with selective public exposure, the optics become combustible. The allegation circulating among critics is that the subpoena functioned less as a pursuit of justice and more as a tool of leverage. A mechanism to gather communications that could later be used defensively or offensively in shaping a broader public narrative. Again, that is an allegation, not a proven fact. But it's the allegation fueling the outrage, because the modern fear isn't just being sued. It's being digitally exposed. In 2026, reputational destruction doesn't require a criminal conviction. It requires screenshots, selective quotes, context-stripped messages, a headline that trends for 24 hours before clarifications ever surface, and when people believe someone with enormous resources can compel access to private digital archives, the psychological impact is immediate. Industry insiders reportedly began asking quiet questions: if they did this here, could they do it again? If I'm ever in a dispute, what becomes discoverable? What protections actually exist for third parties mentioned in someone else's messages? Because one of the most chilling components critics emphasize is the breadth of third-party identification reportedly requested. Not just the communications themselves, but names, contact details, identifying information of individuals mentioned within them from a strictly legal perspective that can sometimes be standard in discovery. Identifying participants in conversations helps attorneys determine relevance, but from a privacy perspective, it feels invasive. Imagine sending a private message to a friend about work frustrations. Imagine that message being pulled into litigation neither of you are directly involved in. Imagine your name and contact details catalogued in legal filings because you happen to be in someone else's chat thread. Even if nothing improper occurred, the experience alone would be unnerving, and this is where the narrative around fear gained traction, not fear of guilt, fear of entanglement, because legal entanglement is expensive. Even as a peripheral witness. Even if you did nothing wrong, the conversation then shifted toward motive. Why initiate litigation through a corporate entity associated with household employees rather than directly as an individual? Why involve a firm known for high-level corporate litigation rather than a more traditional personal counsel route? There may be strategic explanations. Corporate entities can create jurisdictional advantages. They can manage liability structures. They can separate personal exposure from business operations, but to critics, it looked calculated not necessarily in a criminal sense, but in a power-preserving sense, and that distinction matters. Preserving power is not illegal. But the methods used to preserve it can influence public trust. Another flashpoint involved alleged contradictions regarding specific messaging platforms. On one side, claims surfaced suggesting certain chats were unavailable or deleted. On the other, broad requests were made for those same categories of chats from others. To legal analysts, there may be timeline clarifications. Devices change. Backups differ. Access varies. But to the public, contradictions, real or perceived, erode credibility quickly, and credibility, once cracked, doesn't mend easily. Meanwhile, the mainstream media coverage remained relatively muted compared to the intensity within independent commentary spaces. Some outlets reported the procedural facts. Few delved deeply into the privacy implications. Critics interpreted that silence as protection. Supporters might interpret it as lack of substantiated wrongdoing. Silence can mean many things, but in a hyper-connected world, silence often breeds suspicion. Behind the scenes, industry relationships reportedly grew strained. Not publicly. Not with dramatic Instagram unfollows. But subtly. Invitations declining. Meetings postponed. Projects quietly reconsidered. In Hollywood, reputation doesn't collapse overnight. It erodes gradually. A whisper here. A hesitation there. A studio executive asking, is this worth the risk? Because studios are risk-averse. Brands are risk-averse. Investors are risk-averse. They don't just evaluate talent. They evaluate controversy, and even unproven allegations can complicate negotiations. The other dimension of this controversy involves the individuals who chose to push back publicly. Those who signaled they would not remain silent. Those who indicated they intended to challenge the narrative legally and reputationally. That kind of resistance transforms a private dispute into a prolonged public saga, because once both sides commit to exposure, escalation becomes almost inevitable. The broader cultural context intensifies everything. We are in an era where elites are scrutinized relentlessly, where audiences crave accountability stories, where the fall of powerful figures generates enormous engagement, and there is, undeniably, an appetite for watching those at the top stumble, but appetite doesn't equal truth. It simply amplifies whatever narrative gains traction first. If new evidence surfaces validating critics' concerns, the fallout could be severe. If, conversely, further documentation contextualizes the subpoena as standard legal strategy, the outrage could dissipate. Right now, the situation sits in limbo, unresolved, heavily debated, emotionally charged. The most profound question lingering over everything isn't did a law get broken? It's was power used responsibly? That's a much harder question to answer because responsibility is subjective. It depends on expectations, on values, on transparency. For some observers, the mere act of aggressively pursuing digital discovery against private individuals crosses a moral line, even if legally permissible. For others, defending one's reputation through every available lawful avenue is justified in a landscape rife with misinformation. Both positions can coexist, but coexistence doesn't calm controversy. The chilling interpretation critics continue to repeat is this: the subpoena wasn't just about evidence. It was about demonstration. Demonstrating capacity. Demonstrating reach. Demonstrating what can happen if conflict escalates. Whether that interpretation is accurate or exaggerated, it has shaped public discourse, and perception, once embedded, becomes reality in the entertainment industry because casting decisions aren't made solely on court verdicts. They're made on comfort levels, on brand alignment, on whether executives believe audiences will accept a face on a poster without distraction. If controversy lingers, opportunities narrow. That's the unspoken consequence of legal warfare played out in public view. As of now, there have been no criminal findings related to these allegations. No definitive rulings establishing misconduct in the dramatic way some online commentators suggest. That distinction is crucial, but reputational damage doesn't wait for verdicts. It accumulates through doubt, and doubt is contagious. So where does that leave this story? At a crossroads. Either further disclosures clarify intent and neutralize suspicion, or additional revelations deepen the perception that aggressive legal tactics were used to control narrative and intimidate opposition. Until then, what remains is a cautionary tale about power in the digital age, about how litigation intersects with privacy, about how media strategy intersects with reputation, about how quickly public perception can pivot when glossy images collide with courtroom filings, and perhaps most importantly, about how fragile trust really is, even for those who seem untouchable. Because in the end, this isn't just about one couple. It's about the broader question haunting modern celebrity culture. When the powerful feel threatened, what tools are they willing to use? That question doesn't require a verdict to resonate. It lingers on its own, and as this saga continues to unfold, one thing is certain: the conversation isn't over, not even close.